of the CodeX group meeting. We have a tight schedule today. We have three presentations. We have Rolf Müller, the CEO of WAL International and the founder of Müller and Paparis Attorneys, and Paolo Krasnik, who's also an attorney with Müller and Paparis, will give the first presentation. They will discuss the WAL platform, which is a new digital platform for attorneys. And then we have next we have Professor Philipp Hacker, who's the chair of Law and Ethics of the Digital Society Institute at the European New School of Digital Studies in Frankfurt, and he will talk about fairness and algorithmic fairness. And then we have Gabe Tenenbaum and our very own Jameson Dempsey, who will discuss their paper titled "May It Please the Bot." So 3 presentations, we have an hour, so that leaves 20 minutes for each presentation. And I would ask the presenters to actually perhaps contain their remarks to about like 10, maximum 15 minutes. So we have a little bit of time for Q&A also. All right, so before I turn it over to Rolf and Paolo, I wanted to see if anyone wanted to share any news or updates with the group. And you can do so by either unmuting yourself or using the chat function.
Hey, this is Sugam from our stage. Just want to share that we have a
let's see this in the chat.
Special issue call on legal data.
Shugam is sending a special issue on learning from the from legal data in emerging legal informatics paper on ResearchGate. Thank you. Check it out. I don't know if that's something you wrote or if it's something you just want to.
Oh, this is the special issue in my journal, basically.
All right. Good. Well, wonderful. Thanks for that. And let me turn it over to Rolf then and Paolo. Are you there?
Yes, we're there.
Hello, everyone.
Rolf, Paolo?
Yes. You're here?
We can't hear you. You have to unmute yourself.
Yeah.
There you are. Wonderful.
Yes. Hi, everybody.
Good to see you. We still can't hear you.
Rono, it's Thibaut. I can hear them actually, but I think you cannot.
Oh, okay. Yeah, no, it's all good. Sorry, sorry. The problem's on my end as usual. Okay. So, all right. So over to Rolf and Paolo. Welcome.
Welcome, everybody. Thank you for having us here. I'm very happy to be back at Stanford, where actually this idea started 4 years ago. I was attending CodeX and I listened to a speech, and the professor lady there told that one of the biggest problems in US was that 80% of the people didn't have access to law. I went out and I thought, well, that's actually everywhere the same. It's very expensive, it takes time, people are scared to go to lawyers. Court cases last for 5 to 10 years. Yeah, and so this was the beginning of this project, and now we're here. And so we built up a network where we want to have everybody as winner, win-win situation for everybody, and especially access to law for everyone. So Paolo, you may continue.
Yes, we think it's best if we show you way by guiding you through our website, which you can see right now. And the first thing I want to talk about is our services. Whale offers a bunch of services. For one, we offer lawyers to meet on our platform to make a profile and present their case to the public. Another service we offer is called contracts and templates, where lawyers, professionals can share their contracts and templates, publish them on our platform, and make it available to all the clients all over the world. The third service is called Knowledge. This is like a whale journal where attorneys or other professionals can share their opinion or other legal knowledge on our platform by writing an article and publish it.
The third, this is not yet done, but it's in projection, and we started also the technical background of this is contract manager, where you will be able to manage your contract with time limits, with on a blockchain base, to close contracts, to get insurances on the contracts. This will be the contract manager where you could deposit all your contracts. We have a digital court. This is run also by our whale lawyers. I will get back to these lawyers and to the function and what they can get out of whale. Then we'll have secure transactions. That's a future project as well. It's not yet available. The aim will be that you buy something, for example, in Europe, ship it to the States. We have a seller and a buyer. You want to get granted that the goods will be delivered in time without damages or warranties. So we will have a chain that starts from production till the end user, which you can secure by having arbitration, where you can have an escrow, where the payments will be done when the goods will be delivered, everything automatically without any people in between. So back, why should I register as a lawyer and as a client? Well, we think, as I told you, that we want to have a win-win situation for everybody. I was thinking about how will law look in future? How will be the work of a lawyer in future? I think, or we think, that a lawyer will not be able to sell a contract, a labor contract for his clients for $3,000 US, because the client then will go and Google labor contract and download it and try to use it as a template. This is not the best idea. We know it as lawyers. So we said, okay, let's give the lawyers a platform where they can market themselves, where they can offer their legal expertise to clients on a very easy way, in a fast way, and let clients get to these lawyers as well in an easy and fast way. So at Whale, a lawyer can register and put his fields of work, his practicing. Let's say I'm a labor lawyer, so I will open up a profile. I will promote myself as a labor lawyer. And I have two duties as a lawyer when I register at Whale. First of all, I will have to upload 4 contracts to be used by anyone who is using Whale. And second of all, I will have to give 4 times 15 minutes kind of free consultation. So me as a lawyer, I'm giving 4 templates, 4 contracts, and 1 hour a month for everybody out there who can contact me and get easy to knowledge and to answers you might have. Of course, as a lawyer, I'm hoping to get a client after this 15-minute call. And if I get this client, Whale is happy, and the lawyer has a client, we don't get any kickback or anything else. We just happy for the client and for the lawyer. The client who makes use of this lawyer has free access to the app. It's free for any private use. And as I told, you can search for lawyers. You can search for lawyers by country, by field of law, by any publication the lawyer has been done, or uploaded at Whale. So he will get to a rated lawyer where he can trust and contact directly. He will be able to call this lawyer through the app for $6 for 15 minutes. And then either he has his answer or he knows that he will hire this lawyer, and then it's their business to close any agreement between each other, any consultation.
Yes. So Rolf told you that we offer the clients the lawyers, contracts, templates, and knowledge. But let's talk about what happens when a dispute arises. Let's say two parties download a contract and conclude the contract, but one party is not happy with the performance of the other party. So they will have a dispute. And therefore, we have our digital core. The one party can send a notification to Whale that he would like to initiate a legal proceedings, and this will be handled over our digital court, which should be in a legal language and arbitration court. If the dispute is arbitral, of course, you can register on the website, you can file the claim, and you will get referred to a referee who has to sign up on Whale as a referee. It needs to be an attorney at law specialized in this field, and he will automatically be matched to this case. And then the proceedings will go according to our own Whale International Arbitration Rules, which we wrote based on a benchmark, an international benchmark, and our opinion of the future way of handling the case. Another very important thing is our contract manager. After a party finds and downloads a contract for $1 written by a professional, he can manage his contracts in the contract manager. He can register deadlines and performance issues and everything, and he will get a reminder. Also, the law firms can use this contract manager or let's say deadline manager for their law firms, etc.
Yes. Yeah, so when we were talking about win-win for everybody, so if I register as a lawyer as well, as I told you, I have some duties. I will have to upload for contracts. I will have to give this 1 hour free consultation. I have to pay a very small amount of $9 to have a profile, $10 more, $19. I have access to the whole contract library. So I will have access to any other contracts that all the other lawyers uploaded. So it's a huge advantage for me as a lawyer that I can access to much more contracts through all the jurisdictions. Further, as a lawyer, I have also the right to call any other lawyer. For example, I have a client who wants, excuse me, to open up a new company in Italy, and I don't know the regulation in Italy, so I can call an Italian lawyer who is specialized in this field. I will get an answer if it's possible that my Swiss client can open up a company in Italy. And because I'm happy with the phone call I had with this lawyer, probably I will mandate him. So he is happy to get new opportunities to be mandated. If a client downloads my contract from Whale, he will automatically receive a header with my law firm, my address. He can contact me at any time. He gets his contract for 1 Swiss francs. So I'm giving it for free. He pays 1 Swiss franc at Whale, and hopefully and for sure he will contact me as lawyer because he knows that I was the issuer of this contract. I can tag the contract. I can tag the contract by purchase, for example, by sailing boats. So if I'm looking for a lawyer who sells sailing, who wants with an expert in sailing or any kind of law, so I can find him and the right contract through the text that we provide for everybody to like define a little bit more which contracts we're talking about.
Rolf, there's a bunch of questions already. I just was hoping that you could maybe turn over to questions before we run out of time. Would that be okay?
Yes, of course.
All right, cool. So let me see. First question, how do you vet and check and rate a lawyer?
Well, I think one of the advantages, we as platform, we don't rate a lawyer. Everybody who will use the app will only be able to continue to a next transaction when he rated the first transaction. So if you're contacting a lawyer, if you're downloading a contract, you will be able to do a next step in the app only by rating whatever you.
So it's a crowdsourced, basically. Yeah. It's okay.
Possibility.
Okay. And can you get business intelligence graphics from the contract manager tool? Tiago is asking.
Can you explain that question?
Like can you get graphics from the contract? I mean, any stats and that sort of thing, I think is what the question is, from the contract manager tool. Well, maybe let's turn, yeah.
We're talking about this one?
I don't know. You know what? Let's go to the next question, and maybe Tiago can maybe clarify his question separately. So Rachel Saunders is asking, how are you going to ensure that you have enough lawyers on the platform to ensure that A, it is a viable business model, and B, that there's enough choice?
Yes, of course, it's a marketing issue to get these lawyers on Whale. The other thing is that we get requests from clients. We know what the clients are looking for, so we can address any lawyer wherever this client needs him and tell him, listen, we have a client who needs a lawyer. Please register at Whale and give him the answer. So you will win a potential client. So this is also something that we could provide for the client.
Okay, if something wrong happens between a customer and a lawyer that you have approved, then who will be responsible? You or the lawyer you approved?
The lawyer. We are only intermediate.
You're just making connections. Okay. All right. So Mark's asking if this will reduce billing or increase billing to the participating lawyers? I mean, I think maybe the question is, can they increase the billing rate? I mean, presumably you want to increase, clients, the amount of clients they have access to, right?
Yeah. We're sure we will sure it will increase for the lawyer, because we put down the barrier for anybody to contact a lawyer, and suddenly a lot of people will see that they have much more rights than they were thinking before. And as the access is very easy to the lawyer, it's easier for the lawyer to get a client.
Okay, so it's okay. Mark, clarify. Does it reduce the legal costs to the clients, I guess, or increase them? And how does it increase access to justice?
I would say the whole goal of the platform is to make it digitally available. You have it on your smartphone, you download it for free as a client, and you can instantly contact a lawyer or download a contract for $6 or $1. So I think this.
Yeah.
And also litigation would be on a very low price compared to courts. You will have only one instance where you can have your case handled. It's a fixed fee. So the legal costs for any company will be reduced about 70%, most probably, if you will use.
Okay. And Nonopa just pointed out to me that I skipped her. I didn't really skip it. So I just connected the two questions that Mark had, or his clarification. So I didn't mean to skip Nonopa's question. She's asking, how do you ensure lawyers being uploaded on your platform do not go against their employment agreement with their current law firm or employer? It's an interesting question.
That's indeed an interesting question. We are not looking for individual lawyers only, but there is the possibility to register as a law firm, and under the roof of the law firm, every single lawyer can register. So it's not something against the own law firm, but it's in co-relationship.
Mm-hmm. Now I get it. So, okay, so my question is, and then we have to turn to our next presenters. So it seems to me that you kind of put, a lot of different pieces together that I have seen as sort of almost as standalone companies, right? There's companies that do just the agreement sharing, companies that just do the connection piece, and the contract management. So that's I think that's interesting. I think the challenge is in all these kinds of places where you have to bring lawyers and customers together is, there's this kind of chicken and egg question, right? You almost need to seed the system. For the lawyers to be interested to come, there need to be interesting clients. They're not just going to sign up if they don't feel like they can generally get business from this website. They're just too busy, I think. And that's already hard. And then on the client side, you need to, it's like you need to have, the right lawyers on the platform. Anyway, so I think there's lots of examples of companies who've tried to do that. I mean, some, going back, some of the first ones where it was hired legal services back in the 80s in the US. They, Joel Hyatt created this network of Main Street lawyers under Hyatt Legal Services, and for years, and they started with bringing the lawyers on board, and then only later the clients. So it can be a very kind of protracted, time-consuming process, but it's not. I don't think it's impossible, but it's a challenging task for sure. But anyways, I really appreciate you. You giving us an update on this work. I'm excited to hear that it was inspired by you being at CodeX, the Future Law Conference. I believe that was 5 years ago. You said 4 years ago.
4 years ago, yeah.
Yeah. All right, and we're actually we're going out to our next Future Law Conference, which is going to be on April 8th. So anyway, Rolf and Paolo, thank you so much. Really appreciate you joining us. Please keep us posted, and good luck with your project. I think also the cross-border aspect of it is also interesting. Actually, final question. How do you make money?
So now we only spend money, but maybe you register, for $9 US. So then we will make a little bit of money. Yeah, no, we make money by this registration of the lawyers. The contracts that will be downloaded, this $1 US per contract will go to Whale as well. We have a fee for the litigation of 2% that will remain at Whale. And it's the signing fee of the customers and companies, not private persons, and of the lawyers.
Okay, well, that's interesting. Is that where how the percentage in the litigation, how that works? That might raise like fee sharing issues, right? In certain jurisdictions.
We know that.
But I'm sure, you've thought through that. But anyways, thank you so much for joining us.
Thank you.
And let's turn over to our next presenter.
Sure, just quickly, if you could drop your emails into the chat, Paulo and Rolf, and thank you for a great presentation.
Thank
Yes.
you.
Thank you so much. All right, so over to Professor Hacker. This is a great name for.
Absolutely. Thanks. I cannot start my video at that moment. I think somebody has to enable me to do this. It's still
Okay.
all right. It should work right now, and I'm trying to share my screen also. Here we go. I think the other screen, Rolf's screen is still shared, so I have to wait for him.
Rolf, can you please unshare? There you go.
Right. Excellent. Here we go. Wonderful. Thank you. Thanks for the kind introduction, Roland, and for having me at this wonderful meeting here tonight or today in California time. I will share some thoughts on the algorithmic fairness and affirmative action, and that's of course a gigantic issue. So in the 15 minutes that I have, I want to tackle this in 2 steps. First, I'll look at some of the technical foundations and present a model that we have developed that enables us to basically slide between different notions of fairness in a very smooth manner. And then in the second part, I want to turn around and ask if these fairness interventions that we now see increasingly, both in practice and in theory, if they are legal at all under affirmative action doctrine. So starting right away with algorithmic fairness issues here, I want to mention that when we should think about when we talk about algorithmic fairness, of course, what is it that we're talking about? What is it really that is meant by fairness in this context? And you might have heard that there are a number of fairness definitions that have been developed by computer scientists in recent years. Actually, more than 20 are currently circulating, but they fall basically into 2 main groups. So the first group is concerned with individual fairness, and that is obtained if 2 individuals that are very similar with respect to their attributes, except for their protected attributes, if they're mapped via the algorithmic process to similar output scores, for example. So that harks back to an Aristotelian notion of treating likes alike. And interestingly, this is also taken up by the CJU, the Court of Justice of the European Union, in its definition of equality before the law. In the Charter of Fundamental Rights of the EU, equality before the law is defined as treating similar cases similarly. Now, that is one dimension. The other dimension abstracts from the individual, looks at the group aspect. And there we have group fairness dimensions or metrics, actually a number of them as well. And one of the most important ones is statistical parity. So statistical parity is obtained if you have the same positive selection rate for each protected group. Basically, that means that to be positively selected is totally independent from your group membership. That is a more outcome egalitarian concept because, you know, in the end, you get same positive selection rate for each protected group. But it's interestingly also normatively relevant because if you treat different protected groups statistically in exactly the same way, it's almost impossible to find disparate impact or indirect discrimination, EU terminology. Now, as so often in life, the problem is that you cannot really have your cake and eat it too. Oftentimes, when you have different base rates between the different protected groups, different score distributions, for example, think about whatever prices, or think about different conditions, or think about different admissions test scores that are being predicted between these different these different protected groups. If you want to advance or enhance group fairness by enhancing statistical parity, at the same time you will lessen individual fairness because you have to treat different people from different protected groups differently, even though they are pretty close together. Now, that is a problem, and we took this as our baseline and said we might try to find a model that bridges this kind of divide between individual and group fairness. And that's why I teamed up with a computer scientist and a mathematician, and we developed a model that does exactly this, that continuously interpolates between measures of individual and group fairness. And how do we do this? We define a barycenter, which is basically like an intermediate, an average distribution, average between the different group distributions of the protected groups as a target distribution. And then we introduce a parameter theta that allows us to fine-tune the degree to which each individual group distribution is mapped onto this target distribution. So if you choose theta equaling 0, it means that the group distribution as it is just stays as it is, and hence individual differences are fully preserved. Whilst if you're using theta equaling 1, then the group distributions are fully mapped onto the barycenter, onto the target distribution, and statistical parity is fully achieved. And we can actually choose any theta value between 0 and 1, allowing us to basically slide on a scale between more individual fairness and more group fairness as the situation warrants. And also we use a technical feature, basically a mathematical tool from optimal transport theory to ensure that on the way through this mapping process, there is as little information lost for the decision maker as possible. So how does this play out in practice? We evaluated this on the LSAT dataset, which is a dataset that contains more than 20,000 candidates or individuals and their law school admissions test scores. And as you can see here from the descriptive statistics, there are two groups that stand out. So one is the blue group, and those are the white applicants that perform significantly above average. And the other group is the red group here, and those are the African-American applicants that perform significantly below average. Now, what do we do with this? Or what can we do with this? If we believe that this correctly somewhat reflects, aptitude or future college performance, then you can choose theta equaling 0, and you just leave everything as it is. But you might have heard, particularly in California, that the University of California actually discontinued the use of, for example, SAT scores in its admission system, I believe through 2024, precisely because there is a reason to suspect that the differences in these test scores are actually due to social, economic, or historical disadvantage, not necessarily correctly reflect aptitude. Now, what we can do in these cases, if we do want to continue somehow using these scores, and it doesn't have to be an LSAT score, as we said, it could be any kind of output of any machine learning algorithm, or it could be needn't necessarily be a machine learning technique. What we can do is we can choose a higher theta value approximating these group distributions, choosing, for example, theta equaling 0.5 or theta equaling 1. And so that allows us and allows developers, I think, to have a tool at their disposal to basically use it in different situations with different fairness metrics, depending on whether in that one instance or another, more individual or more group fairness seems warranted. So that is something that we can do technically, but the question, of course, now is it legal to do that? And that is problematic, not only because of issues of data protection law, which is an interesting topic in itself, and I'd be happy to talk about this in the discussion, but there's no time for this right now. I just want to focus a little bit on anti-discrimination law, because this enforcement of group fairness can be seen as an instantiation of or running afoul of affirmative action doctrine, or positive action doctrine, as it's called in EU law. And I just want to highlight that there is actually quite a broad discussion about this right now in US literature. There's quite a dearth of scholarship with respect to this in EU law, I believe. And I just want to highlight some of the key distinctions between the EU and the US legal framework and just walk you through a number of questions in dealing with this intricate issue. So in order to fully appreciate these differences, however, we have to look at different types of algorithmic fairness interventions that we can have at basically different stages of the ML pipeline. And what are these? So one way to think about this is to use post-processing tools, like the model that I just showed you that we developed. So basically, you take any given output of an ML model, and then you apply this tool, and you modify this output until it fits your fairness metric, for example, the group fairness metric that we just talked about. We can also, or you can also do similar things with the data before it enters the model, and that's called pre-processing. So usually you would apply these kind of metrics or interventions to the training data, but you could also do this with the application data that is then being analyzed by the model. And finally, there is in-processing approaches, and those usually add some fairness-aware regularization constraint on the loss function of the ML model, and therefore enable it through the learning procedure to optimize not only for, say, accuracy, but also to take fairness considerations into account. Now, the big question, of course, is how do these different interventions map onto the the affirmative action doctrine? And I just want to talk very briefly about the CJU, the Court of Justice of the European Union here, because it has a very interesting and I believe quite unique distinction that distinguishes EU from US law that could be interesting for developers. The CJU distinguishes between two different scenarios. So on the one hand, it says if we're in a selection phase, so if we're in a moment where the key selection is, the key decision is being taken, for example, you're saying this person is selected and the other person is rejected. So if you have obtained a first round of results that is then being modified and re-ranked because we say that now we want to enforce some kind of fairness ideal. In the Marshall case, the CJU said that this is very difficult to do. The criteria are very restrictive for this. You cannot enforce any absolute and unconditional priority of any given protected group. You have to make an objective assessment on the basis of all available information of the specific case, basically comparing the persons that are being down and up ranked. And that means that basically you need a human in the loop and you cannot do automatic re-ranking. However, things are totally different if we're before the selection phase, because in the Bade case, which concerned the invitation to an interview, the court ruled quite differently. So if you have a tool, a candidate screening tool, for example, that checks which candidates to invite for an interview, you can even enforce strict quota at that level. And that, of course, is a much more lenient criterion. And now the question becomes, with these two categories, during the selection phase and before the selection phase, how does that map onto the different fairness interventions that we've just talked about? And so intuitively, or at first blush, you might say that, well, during the selection phase, that looks a lot like post-processing, right? Because post-processing, you already have first ranking, and then you re-rank candidates. Whilst before the selection phase, that might look like pre and in processing approaches because it's before the application data comes in. And that's, interestingly, very parallel to a lot of the scholarship that we see in the US that says, for different reasons, mostly out of the Ritchie versus the Stefano case of the US Supreme Court, that we have to treat post-processing approaches in a very restrictive manner, whilst pre and in processing approaches are more easily to be handled by the affirmative action doctrine. Now, I want to, in my last few minutes, just challenge this result for a little bit. And because I tend to think that we have to ask a number of questions when we talk about the legality of algorithmic fairness interventions here. So first, in an EU setting, we have to ask, are we in a pre-selection process or are we in this final selection setting? If we're in a pre-selection process, for example, this invitation to an interview, then actually you can run pre, in, and post-processing approaches because you could even enforce strict quotas. So the Bade case is actually pretty clear here. If we're then, and that is something that I have, by the way, not seen in US affirmative action law. I'm not an expert there, so there might be something, and if you know something about it, I'd be happy if you could point me to this, but I think this is really unique for kind of a green light for the EU jurisdictions. If we're in the final selection setting, then we have to ask ourselves, both in the US and in the EU context, if we're correcting illegal discrimination or not. Because if that's the case, if barring the algorithmic fairness intervention, the result of the algorithm would basically be to violate non-discrimination law, then in my view, it must be possible to enact, again, pre, in, or post-processing approaches, all the same, in order to make our model compliant. Because otherwise, you would put the users of the ML model in quite a legal dilemma. They could not use the scores because they would be in violation of non-discrimination law, but they could also not modify them because that would run afoul of affirmative action law, and that is not a very logical result, I believe. So if that's not the case, if we're correcting illegal discrimination, again, we have a green light. If we're not doing this, but rather we say, we got some results here, they might be illegal, we have maybe justification for these differences, but we still want to enforce higher diversity in the workforce, in the student body, or whatever, then that becomes a really more tricky issue. And that's precisely where we have this difference between pre and in processing and post-processing approaches, because if we do pre and in processing, then we're basically redesigning the model in the abstract. And this is something where I would say the US and the EU jurisdictions again agree in saying that this is generally possible. This is something that again is also mentioned in the Ritchie versus the Stefano case, and I believe that the same should hold for EU law here. The idea generally is that if you're redesigning the model, it's quite arbitrary what kind of model you started up with. So there is no real benchmark against which you could measure any kind of, and no objective benchmark against which you could measure any kind of improvement of the model. And therefore, people such as candidates don't have any legitimate expectations in which they could say, hey, I thought this specific model was supposed to be used, but rather you are able to redesign the model. The real tricky part then is modifying the application data. If that's what you're stuck with, for example, if you've bought a model and you cannot really change the model, you cannot go back to retraining it, or it would be too expensive or whatever, and you just have to work with the data that you want to apply this model on, then that gets real trickier. And that's my last slide. And I just want to highlight here, because we're already running out of time, that again, if we're in the world of modifying application data, it should not matter really whether that data is modified pre, in, or post processing, if it's really that these approaches do modify the application data. But I would argue for what I call an attenuated Marshall standard in this case. What does this mean? I believe that some limited algorithmic fairness interventions should be possible. For example, if candidates are pretty close to one another, so you have a certain corridor, and you could re-rank these individual candidates, because, or if there is a proven imbalance, a proven underrepresentation of one protected group in this specific scenario. And for a US context, that would be akin to the implementation of a valid affirmative action plan. However, remember that we have this case in EU law, the Marshall case, which says that, ooh, we need to perform this objective assessment of all available information in the specific case. Now, I believe that this would be an overburdening, really, in cases of big data, because the Marshall case was decided in 1997, before, of course, the AI era really took off. Right now, if you have a data set with 20,000 individuals and you re-rank a lot of them, that would just create prohibitive costs. So I think that in this case, we should restrict our scrutiny of the human scrutiny to cases of specific legal interest. And that could be, for example, individual hardship, the single parent, the war veteran, the chronically ill person. And that could be information, pieces of data that could be parsed by a parser and then just flagged and sent for human scrutiny semi-automatically. Or, and that's my final point, a case of specific legal interest where you would have to apply specific human scrutiny would also be reliance. If we do have specific reliance of individual candidates that say, I thought that this kind of piece of data of mine would count at face value, or that this specific decision-making procedure would take place, then that would also trigger the standard, I believe. And that's interesting to note, because again, then the wheel comes full circle. That is precisely, this reliance element is precisely what led the US Supreme Court in Ritchie versus DeStefano to say that the specific test results could not be overturned in an affirmative action manner. So with this, because the time has already progressed quite a bit, I just leave the conclusions up here. And I just want to highlight maybe as a bottom line that I think that with our model, on the one hand, we can bridge sort of individual and group fairness divides, but this resurfaces in the debates about affirmative action of whether we want to have more individual equality or group fairness. Of course, a lot of affirmative action cases right now, specifically with respect to admissions policies in the US being headed toward the Supreme Court. I believe that when we talk about algorithmic fairness, we should allow automated fairness interventions to reduce illegal discrimination, and we should, on the other hand, incentivize meaningful human-machine teaming when it comes to mitigating underrepresentation. So with this, many thanks for your attention. I'm really looking forward to the discussion of this highly complicated and sort of tour de force story that I try to tell here.
This is great. Thank you so much, Philip. Fascinating topic. And very complex. Yeah, I think we'll take a few questions, and we'll just, I think we have 3 presentations today, we'll just go over a little bit over our allotted time. So all the presenters get, full 20 minutes for their presentation and discussion. So Jane is asking, unfairness comes from humans, whether in LSAT development or ML algorithms, not the tool, the algorithm itself. So the intervention is about humans, right? And then she follows up with, is unfairness systematic? If not, can you really apply automatic interventions?
Well, it depends. I mean, there are some it's right that the unfairness, the discriminatory part can come from data, historical data, for example, that is based on human discriminatory decision making. It can also, however, be kind of just a glitch in the ML pipeline where people didn't mean to do harm, but there are cases where, for example, just a feature selection or the target selection value led to discrimination without anybody meaning harm. Again, it was a human mistake, of course, but it was exacerbated by the way in which machine learning works, in that it propagated through the entire system. Now, if we want to correct this, I mean, I guess the great advantage really of machine learning is that we can have a look consciously at the decision-making parameters, and that we can design systems to consciously take care of certain metrics, which is impossible, of course, if we are in a human decision-making context where we don't know what's in people's minds, and we can certainly not steer their minds. So that's, I think, good news to a certain extent. And automating this does not mean that, you know, there is no human programming this or so. Of course, there will be, you know, audits and overview and oversight of generally the model that is being applied. What I wanted to argue is the more constrained claim that we should not be in necessity to have a look specifically at each and every individual re-ranking decision and compare the individuals. If we have 20,000 individuals, you know, and then one person skips 5 ranks, then you have to compare that person with the 5 others before or below him. And then when you do this for 20,000 individuals, that means that we might not do it at all in the end, because it's just prohibitively costly.
Got it. Okay, so then there's a lot of praise coming. Nonopa is saying incredible, and Tabo is saying impressive. Nonopa is also asking, what's the end goal? I mean, that, you know, that's one question. Maybe the final question would be from Barbara, where she said, in this regard, it seems in line with the general iteration approach, where pre-processing is essentially rulemaking and post-processing exceptions. Is the purpose of the revisiting of the model in pursuit of reduction of arbitrariness in making exceptions, and then perhaps pre-processing itself? I think this is definitely fascinating. Not sure I completely understand.
I'm not sure either, given that we're a little time pressed, but I think that the hunch generally is that, yes, pre-processing is more about constructing a model in a way that makes sense and that adheres to certain fairness constraints, whilst post-processing basically fixing the problem more ad hoc, but also you can fix it in a way that is more precise with respect to the decision in which it is applied at hand. So which is why a number of developers that I've talked to have a certain preference for post-processing models, because you know exactly the kind of data that you're dealing with, and you know exactly the kind of results it's going to have. So this is a pro of post-processing, but it might be more difficult in some situations to justify them pre-processing in a legal way. And what's the end goal? Well, the end goal, of course, is world peace, as always. I mean, it's just to generate, I guess, a thorough discussion about the goals that we have behind our fairness metrics, and to raise a conscience about the fact that this actually reflects and mirrors kind of long-standing debates that we've had in social justice and in affirmative action policy, and that they're now resurfacing in all these lawsuits that we're seeing.
Okay, so there's still more questions coming in, but perhaps if folks could follow up directly with you.
Obviously,
Philip, if you could maybe share your email address, that would be great. And then, folks, if you could reach out directly, that would be fantastic. And Philip, if I may say so, it's really fascinating work, and really appreciate you sharing it with our community. And
thanks.
Thanks for joining us, and please keep us posted.
I shall. Thank you for inviting me.
All right, good to see you. All right, thank you. All right, and then next up is Gabe Tenenbaum and Jameson. Are you there?
Hi, Roland. We're here. Philip, if you don't mind sharing back the screen, and I'll take it over for you. You still have control.
All right.
Thank you. Okay, pulling up the slide share. Jameson, why don't you kick us off?
Sure thing. Well, thank you so much, Roland and Susan and Stephen, for having us. It's a pleasure to be back at the CodeX weekly meeting. I'm sorry we can't do it in person, and I really hope that we can all get back soon. So over the course of the next 2.5 hours, we have a short presentation. I'm just kidding. Over the course of the next 15 minutes, we're going to try to go through our presentation talking about our paper that came out last year called May It Please the Bot. For those outside the US, it's a play on May It Please the Court. Essay was published in the MIT Computational Law Report. It's a short essay. Our goal is to put out a few ideas. Hey, Gabe, are you sharing the Google Doc version or are you sharing a downloaded version?
I hope I'm sharing the Google Doc version, but we're gonna have to roll with it if I'm not.
Let's see. Try going to the next slide, please. Huh, strange. It looks like it, Gabe, it looks like it may be a different, an older version, but hopefully it won't be a big deal.
Okay.
Let's see. Let's head on to the next slide. Okay, so let's start with the conclusion, what we're trying to say. What we're trying to say in our paper is that judges should draft opinions with future computer processing in mind. And that includes the writing and the structuring of information to facilitate machine readability and legal analytics. What we'll do over the course of the next few minutes is quickly talk about what a judicial opinion is, what it's trying to do, what the main components of a judicial opinion are, and then we'll talk about some strategies for making those more machine readable at the drafting stage. Gabe, I'll turn it back over to you.
Thanks, Jamison. So let's talk for a minute just about the nature of a judicial opinion. I direct this largely to folks who aren't legally trained or maybe have been trained in a different system than those in the US. A judicial opinion is a tool to inform people about outcomes of legal cases. It articulates the underlying legal principles that was decided on, and it serves as sort of a guide so that others could follow along in the future and know how they should conduct themselves based on that decision. And typically, full dress legal opinions, at least at the appellate level, consist of a fairly consistent group of content types. There's an introductory statement that says something about the nature of the case, the procedural posture about how it got there, says something about the results right up front. From there, it typically says something about what the legal issue is that the court is writing up and the underlying facts that it is based on. It then explicates on the legal principles that it's applying to reach the appropriate decision and gives a disposition, an outcome, along with any necessary instructions. Of course, here, the idea is that these judicial opinions do a bunch of different things. First is they confirm. If you're going to have a society with a rule of law, if you have trial court judges that are deciding legal issues in the first instance, you have appellate courts to say whether they got it right or wrong. The second is they record. Hard to come up with an image there. That's sort of the best I could do. They create a record so that people in the future can be aware that when this set of facts is present, this is how at least this jurisdiction will decide how to deal with it. They also tend to set out tests. So here I've created a couple of, or I've provided a couple of flowcharts that aren't actually included in legal opinions, but others have extracted from them. So if you have a complex problem of law and you need a guidance on how people should deal with that in the future, often the judge's logic can be created in such a way that it uses if then else reasoning. And it is typically written in narrative prose, but it can be extracted in a way that involves a flowchart. But the challenge really is that at least in the US system, judges aren't bound to follow one specific type of reasoning. And when we think, as Jamison's going to explore in just a minute, about how we could parse these decisions, we have to recognize that judges use different tools so that they can make legal decisions and explain the results. They might look at the text of a statute regulation, the intent underlying it. They might look at precedent, how it's been decided in the past, traditions in the society about how those sorts of problems are normally dealt with, and underlying public policy. Incidentally, Wilson Hune from University of Akron, I believe it is, laid out that theory about how judges decide the different modes they might use. And the reality is that judges have different preferences for which combination of these tools they use in a given case. So when we start to think about this question of how could we dig into legal decisions at the appellate level and gather information from them that could be machine readable or otherwise could be extracted? We can hope that judges write using the judicial writing manual. So for our purposes, it's important how judges write decisions so we can think about how to parse them. The judicial writing manual is sort of a desktop standard that the Federal Judicial Center puts up, and it lays out a format that judges should use. And it talks about using things like headings and subheadings to help orient the reader, to use language that helps people know when the legal issue arises, and to give people some context around the way that they're making their decision. So for people like Jameson and I, that makes for an exciting sort of thing to think about. If a judge was to write in this sort of method, what could we do with it? But the challenge is that there's no authority to force judges to write in a clean way that would allow us to easily parse their decisions. The famous judge Posner has said that judges write in sort of two basic ways: pure and impure decisions. The pure are sort of those that follow the logic that the federal judiciary manual would have them write in. It's somewhat ordered, it allows for deductive reasoning to be easily gleaned, and it would allow for people like us who are interested in doing computation to have an easier time. The problem is that legal decisions are often written in prose. Judges can divert from this general path. They can write in the style that they think makes the most sense to them. Oftentimes that means that the analysis and the basis for decisions is garbled, which makes this approach to understanding how to parse language in legal decisions harder than we might like it to be. So let me pass it back to Jameson to talk a little bit about ways we've thought about that we might take this and run with it.
Sure, thanks, Gabe. So first, just want to talk about some of the challenges there are using existing tools with extracting this information. So there have been a number of NLP solutions that have been developed for regular non-legalese language using corpora from non-legalese language. The problem is they tend to stumble on legalese. So these leading NLP models are not well designed to extract information from judicial opinions. As Gabe mentioned, judicial opinions are treated as works of prose. It gives way to individual styles, inconsistent structures, and linguistic features such as irony and humor and sarcasm that are all difficult for NLP or existing NLP to work with. The lack of standards for describing things like when a law is overturned or describing and applying these judicial tests also makes it difficult for computers to trace the application of precedent in a new case or to make sense of the judicial opinion in front of the computer. And judicial opinions contain really important operations and instructions, and these too are very difficult to parse when the judges are writing in their own individual styles outside of consistent standards. So to overcome these challenges, the legal informatics community over the course of decades has turned to some really clever hacks and ways of discovering information within judicial opinions. Just a few include looking for black letter law by searching for the phrase, "it is well settled," as Casetext has done, or looking for case parentheticals to better understand how today's judges understand what's important about past cases, or even flagging cases with negative citation history to determine what is bad law based on the way that future courts refer to those cases. So basically extracting things from the citation standards that we have. Gabe, if we can go to the next slide. But there's got to be a better way. Is today's way the equivalent of smashing a lettuce into a blender using a sledgehammer? I don't know, probably not. But there are at least some things that we can do. And so what we'd like to do is identify some of those over the course of the next few slides. So once again, back to the big idea, or what we're trying to say, is that judges should draft opinions with future computer processing in mind, as if the computer is going to be one of the readers or the intermediaries before it reaches the eyes of an attorney or a claimant or a pro se litigant in a case. And therefore, the judges should take steps, because they're in the best position to do so, to make sure that judicial opinions are well structured and that they include machine readable components. So if you agree, then the question is, what more can judges do to improve the machine readability of their opinions? And let's go through a few of those. So here's the first. It's just plain language drafting. The idea here is that today's NLP relies on plain English language, not legalese. So maybe by drafting legal opinions in plain language, that we can make existing judicial opinions or future judicial opinions more amenable to existing NLP tools. Of course, plain language is not a new idea. It's an old idea in the law, and we're all working towards something like plain language. But there are lots of challenges in our way. So despite the calls for plain language opinion, the trend in a paper from Ryan Whalen at the University of Hong Kong shows that judicial opinions, at least at the Supreme Court level, are actually getting more complex rather than less complex. And a lot of this complexity is received, whether it's from the common law or binding appellate opinions or legislation. So we're not going to change terms like purposeful availment or penumbra in legal text anytime soon, because they're really critical to the way that at least lawyers and judges understand the law today. It's our way of communicating. And even if we improve opinions going forward, we're still going to have to deal with all of the opinions leading up to today. So the NLP challenge will remain. Of course, there are a few things we might do, like mandatory training for law students who are going to become judicial clerks, or legalese grammar checks. Imagine a Grammarly for judicial opinions. Or we could use plain old name and shame, using a SMOG analysis on all the judges in the judiciary and determining who writes better plain language decisions or worse plain language decisions. Let's go to the next slide. So here's another thing we could do. We could use standardized opinion organization or features or even forms. For example, courts could adopt local rules and templates for judicial opinions that are just as exacting and prescriptive as the local rules that litigants are required to follow for their own pleadings. So what might these structured opinions include? Maybe a table of contents and just the requirement for descriptive section headings with arguments. Maybe subsections for different factors of tests, or an explicit section stating what the holding is, or an explicit section identifying any new tests and the specific operations that future courts need to go through. Now, if these features aren't part of the opinion itself, maybe judges could complete short forms that ask basic questions about the opinions, and those forms could be included within PACER as metadata on an opinion. And of course, this also raises tons of challenges, like developing the standards that would govern the forms or these new judicial opinions. Implementing and enforcing the standards is obviously going to be a challenge. I think judges are going to judge and do what they want to do. There are many limitations for especially complex cases and novel issues, and any adopted standard would be forward-looking only. Be really difficult to apply this in an authoritative and backward-looking manner. So let's go to the next slide.
All right, 1 second.
Sure. Another thing that we could do is, for example, build a WYSIWYG that enables judges to mark up their own opinions using standard markup tools like Legal XML. Now, Legal XML or legal markup is not a new idea. It's a many decades old idea, although it's never really taken off in the judicial writing context in the United States. Maybe there are tools that we can build that would enable judges to move away from narrative prose, PDFs getting published in PACER towards something that's a little bit more machine readable, that includes key features that are identified using tagging, at least in the writing process. The ultimate output would still be readable in a narrative format, but the key information would be called out through tagging or markup. Let's go to the next slide, please. Okay, and then the final idea, which is probably the most far-flung, but we think would be pretty cool, would be that appellate court decisions and legislation often include multi-factor or multi-step tests, as Gabe mentioned earlier in the presentation. These tests operate as instructions that lower courts or future courts must apply when analyzing the facts of the case before them. Now, what if we thought about drafting the judicial test like writing a function? And what if applying a test was more like importing that function and running it in the facts of a new case? So we're not suggesting here robo-judges. Instead, it would work more like a flowchart or a Q&A, like the graphics that Gabe showed earlier. These would be like the ones that attorneys are building today in DocAssemble or A2J Author. The judges would still need to explain why they made certain choices along the workflow, so adding documentation to why they made certain decisions, but it would follow a common structure that would enable analysis across cases within individual elements of the test, and would enable future courts and appellate courts to more readily follow the logic that a judge is following. So we think that there are benefits here, but there are also huge challenges to overcome. There would be challenges in developing these standards, in training the judges, in enforcing the standards, developing any technical tools. Once again, it would be forward-looking only. Applying it in a retrospective way would be really, really challenging. And of course, there are normative challenges as well. Oh, Gabe, let's go to the next slide, please. Yeah, perfect. And over-engineered solutions could undermine the human readability and trust in the court system. People who arrive as litigants in court don't want a machine to give them an answer. They want to talk to the manager. They want to understand why a decision was made, and they want to feel heard. If we over-engineer these solutions such that they appear too automated, then people might lose their trust in the system. And of course, automated decision-making in this way, if done incorrectly, could wreak havoc on lower courts and on litigants as well. So I think we need to tread with caution here. So what's next? And how can you help? So this was just an essay. It sets out a number of ideas, but we realize that there's a really smart community within CodeX and the legal informatics community around the world. So we want to know, how would you draft a computable judicial opinion? What are some examples of tests that you think would work really well or really poorly? Where's the low-hanging fruit? What training would be necessary? And how could this go wrong? So we're really, really interested to hear any limitations, any ideas that this sparks, any criticism and ways to improve the essay or the model. And we're looking forward to this discussion. So thank you very much. Thank you for your time. Hopefully we did it in a timely fashion. Thanks, Roland.
Great. Well, thank you, Gabe and Seamus. This is really a fascinating project, and folks have a number of questions. So let's get to those. And we've got to just be running over time today a little bit. If folks are interested in hearing your answers, they should maybe stick around for a little bit longer. All right. So let's see. So Rachel is asking whether there's not a danger that making judicial output more machine readable might risk locking access to justice behind even more paywalls.
So I think that there's always that risk, but the idea here is that at least today, a lot of the tagging, a lot of the NLP that's applied is done behind proprietary paywalls through large case management systems. By moving the process to the judiciary and specifically to the judges, not only do you have something that's well structured and what the judge intended, but also is authoritative. And so the hope is that by doing it in this way, perhaps you could build tools within the judiciary that make case analysis more readily available, or you could leave it up to academic researchers. For example, you could think of Harvard's Case Law Access Project playing a role with something like this. So that the hope is that it would be something that would improve access to justice, not limit it. I don't know if, Gabe, you have additional thoughts on this.
No, the hope is that this would expand access to justice by improving predictability. I mean, one of the benefits of implementing this sort of system is that you would be able to see more data and have a better understanding about how judges decide, and thus know what are actionable cases to make smart decisions about what is justiciable and what's not. So the hope is it would actually expand it, not create a challenge.
Mark Lauritsen's asking, how might we give judges present value in their own work for features in their opinions that facilitate later machine processing? In other words, what's in it for them?
I can take that one. So, one of the benefits of this is that it would, in theory, clear the docket. If it's easier to make a prediction about how judges will behave in a given context, it makes it easier for litigants to decide what they want to do. So the hope and expectation here is that if this was implemented on a broad scale, you would have people that came to court better informed and might choose to plead out or settle or make some appropriate decision because they'd have a better understanding of the law. And again, if we take a step back, the goal of these decisions in large part is to inform people so that they can conduct themselves appropriately. So this is more information to help in that process and would in turn help judges do their job by clearing away the easy cases and leaving them only with the hard ones.
Mm-hmm. Heidi is already coming up with a potential solution. So why don't we give judges Google Forms to draft decisions? Having templates provided for them may ease the transition. It's an interesting idea.
I think it's great. I think it's interesting. Now, whether it's a Google form or some sort of open source tool like DocAssemble, I think that's a big question. But lawyers are already beginning to use these low-code form-based solutions in order to routinize regular tasks. And many of the things now moving away, I think, from the Supreme Court, probably more toward district level, like a court of first instance. There are a lot of routine tasks that would be better accomplished using standard forms than by writing out prose on WordPerfect or in Word.
Mm-hmm. Himanshu is asking, in the interim, is there a human layer which proofreads the judicial opinions soon after they are written and work with the judges to adapt them to machine understandable? So this, I think, this is going to be the job of the clerks of the future. So we need to train them already in law schools to do that for the judges.
That's right. You could create a markup language that corresponded to judicial decisions. Say, judge, you write the decision as you see fit, and then ask the clerk to encode it so that when you went to make it machine readable, you could recognize specific elements in ways that made them extractable.
Mm-hmm. And this is sort of related. So Niliswa is saying, can judges keep the judgments and have two versions, the original opinion and a robot readable one? So this is kind of going in that direction.
Yeah. She's got it.
Absolutely.
You feel sorry for the person who has to do that. So this is some
they may enjoy
the translation. There might be some people who enjoy it. Yeah, we have to gamify it somehow, right? And then Carl is also about the incentives, and Gabe already answered that. Yeah, so you don't have, so Jane is asking, very interesting work. Is there a possibility of retraining some open source NLP systems on your data? But you haven't, I mean, you haven't created a data space for this yet, have you?
Haven't gotten there yet. And one of the reasons we wanted to be with you all today is to get your thoughts about whether that was viable and to see if people are interested in collaborating on that sort of thing.
Yeah. And there's the question whether there's a legal BERT has just been developed. And there's a question whether we should just let NLP take its course, whether it's going to get good enough that this isn't going to be necessary. But we do think there's still a lot of value in having more structured data.
Mm-hmm. And then Scott's sort of suggesting to bring it to 200 other countries. So I think, I think the complexity just for the US is already formidable. And then Ansel's saying a better analogy would be electronic health records, lots of standardized codes meshed with doctor's narrative.
Good point. Good point.
Yeah, it's a great point.
Nonopa is saying, what support stuff would you need to carry this out in courts? I think, maybe we start with the clerk. So anyways.
Yeah, I think the clerks, but it's, I imagine many people on this call have written blog posts using WordPress, and it has a lot of the same functionality. You have a WYSIWYG to know what your blog post is going to look like, but you can always click, hey, show me the HTML so I can understand the markup, and I can use additional functionality. You could use something similar for writing judicial opinions so that for the clerk, for the law clerk, it's the same as just writing an opinion. You just have the ability to do a little bit extra functionality.
Right. And then Laverne's pointing out that empirically courts and judges must already be using some templates, forms, and outlines just to operate more efficiently. And yeah, so that's just it's not a question, it's more just a point. I think that there's some truth to that. And okay, so last final questions, then we have to wrap it up because we're already 15 minutes over. In Europe, the Court of Justice is releasing XML of its decisions. The European Commission is not. I suspect you find similar issues in the United States. It's a
in some ways, civil law jurisdictions make for an easier playground for this because of the formatting of the decisions. There hasn't been a lot of action here in the US, but I think European partners might be the place to start. That would be where I beta tested this, I think.
Maybe Thibault can help with that, as he's like at a European university. So So, okay, and then Scott, the fungibility of digital data judgments compared with paper, for example, and such decisions is at stake here. Thank you. How to plan for governments or independent entities to solve that. Yeah, well, I think,
Money.
giving a presentation at a CodeX could be a starting point.
There you go.
And anyways, I appreciate you guys sharing it, and I hope you got some useful ideas to kind of keep the ball rolling on this. Is very cool project. And thanks, Gabe, and James, if you could also put in your email address so folks could reach out to you. And yeah, it was great presentation. Thank you to all the presenters. Quick round of applause to you all. Thank you for all your great work. Thanks for sharing it with our CodeX community. And yeah, it was wonderful to see you all. Sorry for running over time today, but we had so many great ideas here presented today, and it's great to also have a little bit of engagement with the group. So thanks again all for joining us. We'll be Susan, are we meeting next week?
We have an event on Tuesday. Yeah, can everyone hear me? We are not having. Yeah, we're our very own Michelle Mello, professor of medicine and professor of law, is going to be presenting on Tuesday. And then we meet the week after for our final CodeX group meeting of the quarter. And then there's future law, as Roland mentioned, on April 8th. So visit codex.stanford.edu for more info.
All right. Yeah, and the Future Law Conference, exactly, is at codexfuturelaw.com if you want to check out the conference. And yeah, we'd love to see you for that conference, and also all upcoming meetings that we have until then. Okay. So until then, thanks again to everyone, and see you soon. Bye-bye.
Thank you.
Oh, bye-bye.